Hello everyone, welcome to LAW2022 Online, Immigration Law Shape the Debate. This is sponsored by Trinity College London with me, Alison Castle-Kane, Adam Pipe and Priya Solanki. In this live session, you can put your questions to Adam and Priya and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted questions and also live questions. To the right-hand side of your screen, there's a chat function. All the questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within a few days, so keep an eye out for this. Again, my name is Alison. I work for Trinity College London as the Head of Business Development in the Language Unit. I've been working in the English language teaching industry for about 25 years, both as a teacher, but also in sales and marketing roles in publishing and assessment for English language. For those of you who aren't familiar with Trinity College London, we're a leading international exam board and an independent education charity. We've been providing assessments around the world since 1872. This year marks our 150th anniversary. For the past 10 years, we have been a trusted home office provider of secure English language tests, and we help thousands of individuals in the UK on their visa journey. Trinity CELTs are suitable for applications to UKVI for visas, visa extensions, leave to remain, settlement, and British citizenship. We're proud to be the market leader for CELTs, and we're consistently recognized for the supportive testing environment that we create for candidates. Everyone at Trinity approaches their role with compassion, care, and dedication to ensure that test takers have the best chance of success. You can find more information about Trinity and what we do in the online exhibition at thesolicitorsgroup.co.uk. I'd like to introduce Adam Pipe. Adam has been a barrister since 1999 and practices in all areas of immigration and asylum law. For many years, Adam has been ranked by Chambers and Partners as one of the leading immigration law specialists in the Midlands. In 2016, Adam was part of the Bar Standards Board's Public and Licence Access Review Task Completion Group. Adam was shortlisted for Barrister of the Year at the Birmingham Law Society Legal Awards in 2013, 2014, and 2019. As part of LAW2022 Online, Adam Pipe sessions include a deportation update, immigration, asylum, and human rights update. Priya Solanki is a busy and experienced specialist in immigration, asylum, and national law. She practices for One Pump Court Chambers. She is ranked in Chambers and Partners and Legal 500 as a leading junior in immigration and business immigration law. In 2022, Priya was nominated for the Civil Lawyer of the Year at the Asian Legal Awards. She has a particular interest in and experience of cases involving domestic and sexual violence, mental health issues, and vulnerable clients. She's the chair of trustees at Ma Shanti, a charity that provides assistance to survivors of domestic violence. Priya is also an independent funding adjunctor for the Legal Aid Agency and the co-chair of the Legal Aid Agency Review Panel. Priya's sessions for LAW2022 include Case Law Update, Family and Private Life Claims, Article 8 ECHR, Immigration Medical Cases under Articles 3 and 8 ECHR. Where are we now? So to kick off, we will start addressing some of the pre-submitted questions that we've been receiving from you. Okay, so the first question is to Adam. What is the position now for durable partners who married after 13th of December 2020 and didn't apply under the EEA regulations?
It's great to be back answering questions with Priya and Trinity College. Although I'm starting on a bit of a negative question in terms of those who married after the 31st of December 2020. For those who've watched my session, I certainly cover the case of, is it Celik or Celik, which is one of the two cases that came out from the president. The other one was Batul, in relation to arguments under the withdrawal agreement. So in Celik, the case was rejected by the president because somebody who married after the 31st of December 2020 couldn't meet Appendix EU, and the upper tribunal also rejected their arguments under the withdrawal agreement. I understand that applications have been made for permission to appeal to the Court of Appeal, so I think it's very much a case of watch this space. But in terms of appeals, obviously they're going to fail on those grounds. In terms of where do we go, because I think it's very difficult, because as a lot of practitioners will know, due to COVID, people couldn't get married and just couldn't get those registry office slots. And in other areas of immigration rules, there was provision for those who were affected by COVID. So it seems very difficult. There is the option of trying to raise Article 8 as a new matter. And I know there's a question coming up in relation to that. So, but the Home Office guidance in relation to that does indicate that the Home Office are unlikely to give permission to raise Article 8 as a new matter. The other option, I suppose, is to make an application under Appendix FM. Appendix FM now provides for those with pre-settled status to apply on the basis of their relationships. But obviously an in-country application with somebody without immigration status is going to have to show there are insurmountable obstacles. So I think it's a very, obviously the other option is returning and applying for entry clearance. Rather than ask Priya what her thoughts are, I know that she's got a question coming up about Article 8 and EUSS appeals. So it may be that she might want to touch on what I just said in her answer to that.
Great. Okay, let's move on to the next question. And I think this is for Priya. So in what circumstances can you argue human rights in an EUSS appeal?
So this does flow on from Adam's conversation there about Chelik. Most of you who are now familiar with that decision will know that EUSS decisions, even if you've raised human rights in your application or in a covering letter that's accompanied it, or if it's obvious that there are children involved and it's a clear Article 8 case, it's not being considered as part of the decision. And so what that means is that it can't be raised as part of that appeal. It will be considered as a new matter. And so the only way that it can be considered is if consent is given to it as a new matter by the Secretary of State. Now, Adam, I don't know what your experience of this is, but mine is that consent is being refused routinely by the Secretary of State. And that has included in cases where there are very young children, and even in cases where, in one of my cases where there was a child with a disability. So you do have an option where you have got a refusal of consent. What you would need to do is you would need to think about whether or not you want to challenge that refusal of consent by way of pre-action letter in judicial review. And what you would be asking for was for any appeal to be adjourned pending the outcome of the judicial review challenge to the refusal of consent. Now, they have got a very helpful policy guidance document called the Rights of Appeal Guidance, which sets out the circumstances in which consent should be given. And that suggests that consent should routinely be given to argue everything in one appeal, because otherwise it just delays the whole process. But that isn't the approach that's being taken. So you would either have that option of thinking about judicially reviewing that, or, as Adam has said, making an Article 8 application. Adam, is there anything that you can think? I think,
yeah, because obviously they've amended that Rights of Appeal guidance now, which is generous to non-EUSS and says things should be considered, but in relation to EUSS suggests that they're not going to give permission. In one sense, that might be a blessing in disguise, because I worry that with the decisions in Chelik, people are going to think, right, we've got to rely on Article 8, where they haven't actually teed it up from the start. And the advantage of making an application is you can at least then argue everything. I think your example with a disabled child is one perhaps in a different category altogether. But for your run-of-the-mill case where they just made an EUSS application as a durable partner, for example, it may be better to think, well, let's hold back and make a proper Article 8 application. I did have a case the other day where we had to lose on the basis of Chelik and Batul, but we didn't ask the judge, but she made some rather generous findings which would help in our Article 8 case, even though we hadn't asked. So potentially there is that scope going forward.
Excellent. Let's move on to the next question. This one is for Adam. Are judges allowing examination in chief following the new practice direction?
That's a really interesting issue, because as those of you who have watched the webinar and will be aware, I cover the new senior president's practice direction, which I think goes back to May 2022, but it seems to be filtering down now to the first tier tribunal. And there's a real important section at section 5 about witness statements. So anybody who's drafting witness statements needs to be really aware of that, how the statement of truth should be set out, what the content of the witness statement is. And one of the things they say, and I'm just looking at it now at 5.3, is only in exceptional circumstances and with the leave of the tribunal will a witness be permitted to provide additional evidence in chief. Now, in my experience, a lot of judges have still been permitting evidence in chief, but it has started now, and I've had a local judge here in Birmingham and judges in London stopping evidence in chief. So I think when drafting witness statements, I think the mindset has to be, let's get everything in there. Obviously, if Adam and Priya can ask some questions in chief, all good. But if they're stopped, at least we know it's there. And therefore, if there's a factual development, put in a new witness statement on my HMCTS, seek to rely on additional evidence just in case judges do stop it, because that's the direction of travel, certainly. I don't know what your recent experience, Priya, in terms of have you been stopped in this in terms of questions in chief?
I have been told even before starting, Adam, that everything should be in the witness statement. And I have to say, most judges have allowed a few questions, but I think you're right. You need to make sure your witness statements do cover everything.
No, absolutely.
Great. Let's move on to the next question. This has come in live through the chat. And I think either Priya or Adam, you could answer this. I'll leave it to you to decide. Can a child of a person whose parent is the durable partner of an EEA national apply for a family permit? The relationship, yeah.
Child of... I'm just trying to work through that, Adam.
Yeah, absolutely, because the child would be the child of an EU national in any event. I presume it's not clear if the child is in the United Kingdom or out of the United Kingdom. I presume because it's a durable partner, they would be in the UK already. Obviously, if there was settled status, the child would be British in any event. So, and then they would, if not, they say the European parent had pre-settled status. You would have thought you could apply under Appendix EU in any event, or EUFP if they're a joining family member. Say, I've had cases where you've had a European national in the UK with a durable partner, but they've got a pre-existing child back in Romania, for example, and then they've joined. So yeah, I don't see a problem with that, certainly. That's without looking anything
knowing more about the case.
Yeah, no, absolutely.
Okay, great. Let's go on to the next question. This was pre-submitted for Priya. Can you explain the impact of KA and ORSR on the application of versus Secretary of State for the Home Department and ORS Review 1? This relates to EWHC 2473 on biometrics in entry clearance applications.
Okay, yeah, sure. I mean, that is a really, really great decision, and it builds from an earlier decision that was made. What ordinarily individuals that submit entry clearance applications, they have to go and submit their fingerprints and have photographs taken. And of course, with Afghanistan, this is normally done at a visa application centre, but of course, with Afghanistan, there isn't one. And what the Home Office's guidance said was that these individuals, they should think carefully before submitting applications and paying fees, because their applications wouldn't be considered up until the point their biometrics were submitted. And of course, if there's no application centre to submit them, that makes it almost impossible for their application to be considered. So there was a challenge to that by the family in this case, who were applying to join their British national father. And the challenge succeeded, and in fact the Home Office accepted that they do have discretion in waiving biometric requirements, and that they would look at the individual circumstances, and that when they had written that guidance, they'd done it in the heat of the moment, and there was an obligation upon them to consider whether or not to exercise their discretion to waive the biometrics requirement. The important thing to take away from it is that you should be asking them to do that if biometrics cannot be submitted. Now, all that it requires them to do is to consider the merits of the case and to look at whether or not to exercise discretion in respect to biometrics. But of course, they might decide not to exercise discretion in respect to biometrics. And then you would need to think about whether or not you wanted to challenge that decision by way of judicial review. Adam, can you think of anything else to add to that?
No, it's a positive decision, certainly, and I understand they've changed the application forms as a result of that. Yep. that decision. So certainly now it allows those who, particularly in Afghan cases, who weren't able to apply biometric issue, but nothing further to add in relation to that.
Great, let's move on to the next question, which has come in live. I think for either of you, if you could touch quickly on the changes to stateless parents and that parents now have to explain why they kept the child stateless. How will this affect the parents who do not have any leave to remain in the UK, but are applying for stateless children to become British?
Wow, that's a bit of an in-depth question. I think it probably needs us to do some looking at what I think it's referring to, and I've been deliberately in my sessions avoiding the Borders and Nationality Act, is Section 11, I think, of the Borders and Nationality Act, which inserts a new section into the Schedule 2 of the British Nationality Act, effectively making it more difficult to register stateless children as British, because the Home Office, and this is particularly, I think there's been a big issue with Indian nationals, and there was the case that Mr. Ockleton did sitting as a Deputy High Court judge. Was it
MK?
Yeah, certainly. So I don't think the government like it. They're obviously trying to close down on that, where they think people have deliberately not registered their child, say, as Indian, and therefore, to try and get British nationality. So it's obviously toughened things up. We'll have to see what it does in practice. I think the question asked, I'm just looking back to the question, just scrolling in the chat, about how it affects the parents. Obviously, what the parents have been traditionally doing is getting status for the child and then relying on the child then being a qualified child to argue, say, in the context of Section 117B, that Section 117B6 applies, and it wouldn't be reasonable for a qualifying child to return, and that they should get leave off the back of the child. So the obvious knock-on effect is, if it's harder and they're going to start refusing these registration applications by children, parents are not going to be able to succeed. Obviously, it's very early days to see whether we will see refusals in practice. I don't know if you've had any recent experience of this, Priya.
No recent experience of it. I mean, I've just been looking at Section 11 now. I mean, I think what's being referred to is 1142, in which it said that a person's able to acquire a nationality if, in all the circumstances, it's reasonable to expect the person to take the steps which would enable the person to acquire the nationality in question. I mean, to some extent, you have always had to show that you have actually taken steps to try to obtain the nationality. I think Adam's right. We're yet to see how this is going to play out in practice and the impact that it's going to have.
Great. Okay, let's move on to the next question. This is more kind of an observation question. So many applicants are waiting for a decision on their admin reviews following refusals of pre-settled applications for their non-EU partner. Applicants have been waiting over a year. When we requested an update, the response is we are understaffed. Is there anything we can do other than JR or pre-action?
You can raise a complaint. That's the other thing that you can do. But my experience is that once you send a pre-action, they actually start moving the case along. So often it's a good step to take to try to encourage some movement in the department. Adam, I don't know whether there's anything else that you...
I've certainly JR'd 2 of these, and it was just, I think that the emails when they'd been chasing them up, there was, oh, we've had a backlog and a significant increase from, I think, January 2021. I think these were obvious ones where people had won appeal under the EPA regulations, and as a result of that, their EUSS applications should succeed. But as I've seen, in the ones I've seen, certainly they have put in summary grounds of defence and are fighting them, but they've not really given any proper reasons for the delay, and they not really, there was not complicated cases. My worry is that in any delay JR at the moment, the Home Office will hide behind COVID and Ukraine, and there'll be a lot of judicial leeway in relation to that. So I think we've got to really just warn clients. Some clients will come to the end of their tether and say, right, I want to instruct you to draft JR grounds, let's see. And hopefully, like Priya says, we get a compromise at the pre-action stage, and they'll say, right, we'll make a decision within, well, usually they'll say 3 months, won't they? And you probably have got to accept that as good as you've got. But I just worry that they'll hide behind that. So we need to warn clients, but JR is the potential route.
Just to add to that, I think Adam is absolutely right that they really do hone in on Ukraine and COVID. But in these cases, if you can show it's actually causing particular detriment to your client, that's what you need to focus on. You need to be very quick if there is detriment, and you need to be explaining what the detriment is. So, for example, it might well be that, they've got somebody unwell abroad that they're unable to go and visit, or it might be that it's impacting upon employment in that their employer is the ability for that individual to be able to work. It may well be that it is also impacting upon the individual's health and their anxiety. If you set all of this out well, then you'll be able to argue potentially that it's causing particular detriment to the individual and that the Home Office are failing to alleviate it, which is one of the grounds of challenge in an unlawful delay case. And usually the Home Office don't engage with any of the detriment that it's causing. They just say, we are really overwhelmed and our department is facing this, this and that, and we'll make a decision within X months. And that doesn't alleviate your client's difficulties. So think about raising those issues if your client is telling you to go to judicial review.
Brilliant, thank you. And I'm sorry for the background noise there. I think we've sorted that out. The next question live, and I think this could be to either of you. Is there a provision for domestic violence claim in EUSS European cases?
I think the short answer to that is no, isn't it? And was there a judicial review challenge, Priya? I'm sure that there was certainly a wider JR challenge, wasn't there, in the fact that the DV-ILR was limited, which I think failed, but I don't know if you've got any thoughts on that.
So it is possible to argue for retained rights if you've been subjected to domestic violence in an EUSS case. I'm not sure if that's the question that's being asked. So yes, if you're looking for retained rights, and in fact, the way in which it's been worded, retained rights for victims of domestic violence in EUSS cases is actually quite broad. We're not just looking at spouses or unmarried partners. It also applies to children under the age of 21, dependent children over the age of 21, dependent parents and dependent grandparents. If any of those individuals have been subjected to domestic violence, then potentially, if they meet the requirements, then they will be able to seek retained rights under Appendix EU. Now, in terms of seeking settlement, everything under EUSS depends on the length of time that you have been here. So if you've been here for less than 5 years, you're looking at pre-settle status. And if you've been here in excess of 5 years, then it's settled status. That is obviously different to the DV-ILR rules, which allow for settlement for spouses and unmarried partners. So that there is clearly a difference there. The other difference is under Appendix EU, if you're not successful, you get a right of appeal. And in DV-ILR cases, you don't get a right of appeal. And in those cases, there may well be really strong human rights issues. Now, in terms of the DDV concession, that isn't what the question seems to be asking. You qualify under the DDV concession, so the destitution domestic violence concession, if you meet the DV-ILR rules. So if you don't meet those requirements, if you're not eligible to apply under the DV-ILR rules, so that means you're not a spouse or a partner of the right type of person, a British person, a settled person, a refugee, or a person who's been granted leave under Appendix FM as a partner of an individual with settled status, then unfortunately you can't make use of the DDV concession. It's all very complicated, all very messy, but that's a summary of the current situation.
Just one recent case, there was that helpful case the other day in relation to the DV-ILR rules on that transnational marriage abandonment. Yeah. That's really helpful. A case called AM, where obviously spouses are taken abroad and then left there by, say, their British husband, who comes back to the UK and they're stuck, and the DV-ILR rules were found unlawful in that respect. So there's some helpful movement. I appreciate that doesn't answer the question, but yeah, some good judicial, helpful approach. I think it was Mrs. Justice Leavin in that case. So helpful.
Okay, I'm going to go on to the next question. This is on, again, admin review under EUSS and fresh applications. Appendix AR EU and the relevant guidance suggest that the applicant can make a fresh application under any part of the rules whilst an admin review is pending, in contrast to normal admin review, which considers that the AR is terminated and the fresh application is considered out of time. But does that mean that 3C leave extends, given that 3C does not allow for new applications, but only variation of a pending application? Would a new application be considered as a variation of the one that is under review? Hope that makes sense.
Adam, I hope you've been able to follow that bit with me. I'm still reading that.
Anybody who asks Section 3C questions on an event like this should be kicked off immediately and never allowed back on, because Section 3C is difficult. What I think they're saying is, obviously, if you're allowed to make a fresh EUSS application whilst an admin review is pending, let's say that admin review is then refused, does the fact you've made the EUSS, the fresh application, continue Section 3 leave while that new application is pending, where it normally wouldn't? That's my understanding of the question. Now, the answer is a whole different ballgame. I think I'm quickly checking Section 3 of the section in its current form. Because normally the answer would be no. The admin review would extend 3C, but any new application would not. So I'm saying normally that would apply unless there's, because obviously section 3C was amended. And it may be that we'll have to get back, or the person will have to contact separate. Yeah.
So that we don't lose time in answering.
No, exactly. Just having a quick look at section 3C, I don't think it does. But that's just a quick guess that the second application doesn't, even though you can make that second application, I don't think it extends section 3C. But I might be wrong, and we could have a quick look. But that's my gut instinct straight away. But I'm happy to be told I'm wrong on that one. All right.
Okay, shall we move on to the next question? This is actually related to a question that was asked earlier, but I think we got some additional details. In fact, that the child was a stepchild. So can a stepchild of EEA national, of a person whose parent is the durable partner of an EEA national, apply for a family permit? The relationship predates Brexit. The child is outside of the UK and is 20 years old.
So we've got a stepchild of an EEA national. I think that's, I'm not sure about where the part in between. The important part is a stepchild of an EEA national. Can they apply for a permit, an EEA family permit, when they're outside of the UK and the child is 20 years old? Well, children are under the age of 21, and the definition of child in Appendix EU would have to be looked at.
I presume it looks like it's the child of the durable partner. So your durable partners here, they've got a 20-year-old abroad. And I think what the question is saying is, can the EU national apply for them as I think, you know, so it's basically, how do you get the 20-year-old kid of the durable
the UK? I see, Adam.
Yeah, okay. I think in terms of, there are because there's a definition of what an adopted child is in Appendix EU family permit, and a definition of a child.
I mean, just having a look at, there isn't specific reference to a stepchild in the definition of a child. I don't know from those facts whether or not the child has been adopted. Potentially, if they were, you know, that might make things easier.
No indication if the durable partner, who is the other parent, who's the parent, has got status either. So,
I think maybe this individual needs to try to contact one of us and seek advice about on the fact. Yeah. It appears something that needs to be looked at in more detail.
But I think both of us can see there are potential problems certainly within the definition. So just as a sort of, you know, for others listening, I think there are potential problems with that situation and getting that child over, I think.
Great. Okay, let's move on to the next question, another live question. We've had a refusal of the dependent parent of a British national due to not having serious medical grounds. If we were to launch an appeal, we would be able to rely on the new ADR rules during the appeal, or are we limited to appeal grounds due to applying under the old route?
I saw this question earlier, and I may be being thick, and it's not beyond me at all, but I don't understand what they mean by the old.
No, do I?
And the new. As I understand it,
there's been no changes.
There's no changes to the adult dependent relative rules. So the ADR rules are out of country. There still needs to be those conditions that you need that day-to-day care, and that it's not available or not affordable in the country. So so there are no changes in terms of ADR. If you appeal it, obviously you'd have to show you met the ADR rules or articulate outside of the rules. As you know, ADR are very difficult appeals to succeed in. Some judges, I think there's a bit more generosity now.
I think so. I really do. Yeah.
I think the success average has gone up a bit, certainly in ADR. But then some judges will allow them within the rules. Others are willing to engage outside of the rules, showing those cultural factors, particularly where there are religious, things that you want a female relative or something caring. Getting country evidence, particularly in relation to the absence of care homes and those kind of things, and getting good medical evidence showing the need for care, because it sounds like the problem was that there wasn't good medical evidence in relation to showing the need for the care. In terms of, obviously, this does raise the whole issue of new matters as well. The fact you may, particularly, perhaps the difference I was just going to say in relation to appendix private life, but it's not, it's ADR, it's out of country, isn't it? So there are no change in rules, certainly. I don't think there's any change in rules. Yes, so appeal it, but get the evidence together, certainly. Yeah.
Okay, great. Let's move on to the next question. An individual has been in a relationship for 20 years with his British wife and is also a carer under the Care Act for his elderly mother. The application was refused under paragraph 353. PAP submitted and SSHD maintained decision. Should a JR be pursued or a fresh application, as this individual has submitted 5 previous applications and again been refused?
Okay, so it's very difficult to advise on this type of scenario in this setting, because what Adam and I would need to see would be the previous decisions that have been made. And of course, if any of those have been made by a tribunal, then the tribunal's decision is the starting point. And what you need to look at under 353 is whether there is significantly different material that has been submitted, and then whether that material creates a realistic prospect of success. So that's more a fanciful prospect of success, and whether there's been anxious scrutiny of the material. So as well as having those decisions to look at whether there's been anything significantly different, we would need to see the actual decision being challenged as well, to see whether there's been anxious scrutiny of the evidence, and that means we'd need to see the evidence too. I mean, in principle, it sounds like this individual has an arguable claim under Article 8, because he's in a relationship with a British national, and he's also a carer for an elderly person. It isn't clear whether the elderly mother is also British, but in principle, it does sound like potentially there is a good claim there, and that it might have a more than fanciful prospect of success. But I'm reluctant to give a firm view on that without actually seeing the evidence and documents.
I think Priya's exactly right in that it's a lot to do with the evidence. If it's just the same evidence it's been rejected on that was always there, Priya's outlined the 353 test to you, it's not going to get past it. So if it's the same old evidence, you're going to need to get fresh evidence. And this is, by the time you get to sort of the 6th or 7th application, you're going to need expert evidence. So, like a social worker who's used to assessing adult care needs. And particularly, I suppose, let's presume, as Priya was indicating, that the parent is British. Why, again, they need their child in the UK caring for them rather than social services, which will be the argument from the Secretary of State. And you can combine the relationship as well. So I think, if you haven't got significant new evidence in this application, there is no point judicially reviewing. But again, I agree with everything Priya said in relation to that.
Good. Okay, let's go on to the next live question. Non-EU national parents enter the UK as family members of an EEA national, but have a young child abroad. Have a young child abroad. Can that child make an application to join their parents in the UK?
I think this might be suggesting we've got maybe dependent parents or extended family members, or family members of an EEA national in the UK who have left their child abroad. I think if that's your understanding, Adam.
It sounds like it's like dependence of dependence, effectively. And my instant reaction was, so they've entered. It doesn't say who was the EEA national they entered as dependents on, but they want to now bring their child over to the United Kingdom. If they entered as dependents, I don't think they've got any basis then to bring their child over under any EEA or EU provision.
Article 8.
Yeah, so I suppose we're not told whether they've still got some sort of either 5-year residence permit or pre-settled. If they're not settled, it would be very difficult in Article 8. If they are settled, I suppose they could then make an application under one of the children route and argue Article 8 outside the rules. So again, quite a specific query without knowing more. I think that's our sort of general thinking on it, definitely.
Okay, great. Let's go on to the next question. So in terms of individuals who have leave as a parent under Appendix FM, is there any point now in applying as a Zambrano carer?
I think that's a question to me because I covered Akin.
Sorry, yes.
Yeah, no. I covered Akin Sanya. Priya's welcome to have a go, but I think the answer is probably no if somebody's got leave as a parent. So I always describe Akin Sanya as a bit of a no-score draw in terms of the outcome of the appeal, that the Secretary of State lost the appeal on the interpretation of the EA regulations, but the Court of Appeal agreed with the Secretary of State as to the true interpretation of who is a Zambrano carer. And the Secretary of State's policy is that they're maintaining the requirement that somebody doesn't have leave to remain under another part of the immigration rules. So if you have leave to remain under another part of the immigration rules, you're not going to succeed as a Zambrano carer, and you'll need to keep that leave alive. I think, and I'd be interested on Priya's thoughts of this, in terms of those, we did get those refusals said you could apply as under Appendix FM. And I think somebody who hasn't, got leave, who could apply potentially under Appendix FM, could still apply. Obviously, there's time issues now because even with the policy, they gave a bit of extra time to apply. So still, it would be difficult. But I think Zambrano, for those who haven't already got on that route, is becoming a bit of a dead end at the moment.
I agree, Adam.
Okay. Great. The next question actually is to Priya. So what sort of health claims are succeeding post-AM Zimbabwe?
Okay, so I think maybe a good starting point is to look at what happened in AM Zimbabwe in the upper tribunal. So AM Zimbabwe was somebody who was facing deportation following a 9-year sentence, and was HIV positive, was on AVR drugs, and was having monitoring and testing in the UK. And he was saying he wouldn't be able to receive the treatment that he needed abroad. If you look at what happened in his case, he was somebody who was quite unlikable, and in fact his counsel in fact conceded that he wasn't a particularly likable person, and that factored into the assessment of his evidence, and his medical records and the evidence from the consultant that had been treating him was to the effect that he had missed appointments whilst he was in the UK. And he had gone without treatment at points. And so that was taken into account. The evidence that was produced in respect of treatment availability in his home country came from 2 experts, but those experts, their opinions were very different, and neither of them had actually sourced their opinion. And the tribunal was very critical of their evidence, and they said that what they would like to see in these cases is evidence from clinicians that are actually treating that illness in the home country. So ultimately, AM's case was refused, and it was refused on the basis that he'd gone without treatment at points. He had they considered he had family support that would be available to him on return. The treatment would be available to him. He would be able to work. which means that he would be able to afford the treatment at a low cost. But what really factored into all of this was the quality of the evidence that was produced and his own approach to his health whilst he had been in the UK, and of course his credibility. So what I would suggest in these cases is that you focus on getting good evidence of treatment and diagnosis and prognosis from treating consultants in the UK, that you focus on getting evidence from experts treating that illness in the home country, that you gather good objective evidence as well, that you look at public health facilities and private health facilities, and that you address issues about family and social support that would be available on return. Have a look at the case of MY suicide, which is an upper tribunal decision in which an individual had mental health issues, and in fact his evidence showed that he hadn't always had regular treatment, and he wasn't having the treatment that he needed currently whilst in the UK. But nonetheless his case succeeded because he produced a really thorough medico legal report on what would happen to him if he was returned, and it was accepted that he wouldn't have family support upon return, because at points he'd been destitute in the UK, and that was reflective of the fact that must have happened because he was without support. So consider that case, and that might give you an example of what's needed to succeed.
Great. Okay, let's move on to the next question. This is coming live. Can someone with a 30 months visa as a parent of a British child bring their partner from overseas and apply for a spousal visa, I guess? Yeah.
I'm going to say no, but yes. So technically under Appendix FM, they wouldn't be able to apply under the partner route. But there may be a basis, particularly relying on the best interests of the child, to make an Article 8 argument, relying on Gen 3.2 and 3.3 to argue that. I suppose you'd have to make a notional Appendix FM application and say why you should be exempted from that requirement, because the result would be unjustifiably harsh. I don't know, Priya, if you have any other thoughts on that.
No, I think you've correctly stated the position there, Adam.
Great. Okay. Next question is to Adam. How do I get permission for an appellant in India to give evidence by video at his entry clearance appeal?
This is a big issue at the moment, because I think one of the things with COVID and appeals moving online, a lot of us thought, great, we can call our clients from abroad. And sometimes we did and got away with it. There was obviously the old case of NARE, which was very strict in its requirements. The upper tribunal then promulgated a new decision in, and I always have to look at it and read it carefully, Agbabakia. And then we've had some presidential guidance. The latest incarnation is Presidential Guidance Note number 4 of 2022, which I think comes from July of this year. So you have to apply on notice. It says to the resident judge in the hearing centre, but I presume, as most of your cases will be online, everything will have to be done through My HMCTS. And there's a list of exactly, you've got to set out who the witness is, why you're calling them, what you're going to prove with a witness statement, how they would give evidence. And then they'll revert to the Home Office to see if that evidence is agreed or in dispute. If it's agreed, obviously there's no need to do it. If it's in dispute, in the past, we had to show that there was no objection from foreign governments. Now that's done through the Taking of Evidence Unit, and I understand they've contacted all foreign governments with whom there's a relationship in order to see if there's permission for people to give evidence. But there's a strong, now if they refuse evidence, you won't be able to call, and you have to think of other ways round in terms of perhaps asking questions through interrogatories. But if they do, even if they do give permission, the tribunal has said, well, we're still going to look at the overriding objective, and there's that big hint in the practice direction. Look, we're not going to delay appeals just to wait for it. So often think if your client is the best person to give evidence, then there may be cases where actually you want your client, because they are the best person, they need to give evidence. Often, say in a spouse appeal where the client has been here previously and overstayed, he's the worst person in the world to want to give evidence, and actually the sweet spouse here who's the British citizen with health problems is the one you want to call to give evidence. So think tactically. I've got a case ongoing at the moment with a adult dependent relative, but she's a woman in her late 20s, early 30s with horrible health problems. And we're going to try and show, she's in Iran, so we're not going to get permission for her to give evidence, but we're going to try and get it to show, we've got permission to show a video of her, like showing her around the house and stuff. So I'm not sure if that's evidence through the back door, but there might be other ways of sort of having your appellant take part. There is a separate provision for clients observing appeals, and that's different if they just want to observe. And there are obviously separate provisions in terms of Section 94B, removal cases.
Yeah, I mean, I was just going to add to that, Adam, that obviously this is an entry clearance appeal, and ordinarily in entry clearance appeals, it's just been sponsors that have given evidence. So I can imagine applying the practice direction, it would be considered that it's just unnecessarily delaying matters.
Yeah. I saw a case the other day, a determination from during COVID, where the judge had taken a point against the appellant, the fact under 32011 that they hadn't called him to give evidence from abroad, which I think was very harsh. I was dealing with a new application, but I thought that was extremely harsh because of the difficulties, and the judge hadn't considered the difficulties involved in that, certainly. So I think you're right. The presumption is that it's the norm is not to have them give evidence, definitely.
Excellent. Okay, the next question is for Priya. I have a client that has no family in the UK, but has serious health issues and is being supported by church members and a charity. I've read the decision of Zimbabwe, which says it is only where there are firm family ties, for example, that Article 8 is engaged, and health can then be raised as an additional factor. What advice can you give on arguing this?
So my advice is have a look at the case of Akalu, which is a 2013 upper tribunal case. And what that very clearly says is that Zimbabwe doesn't establish that where an individual doesn't have a strong private or family life, they're not able to rely on their health as part of their Article 8 case. Their health has to be considered, and it must be considered as part of the claim, regardless of that. And when you look at Akalu and the facts of it, she didn't have a family life in the UK. She didn't have a particularly strong private life. She had been here lawfully. She had become ill here while she was here with lawful leave. And her private life extended to that stay, which wasn't particularly lengthy, and having established community ties. But nonetheless, her claim succeeded, with the health tipping the balance in her favour. So that's the way that I would suggest you would get around that. The head note of Akalu makes very clear that Zimbabwe doesn't establish that if you've not got family life, that's the end of your case. You simply can't rely on Article 8. Also think about Ben Said. Your health is an indispensable precondition to the enjoyment of your family and private life. Yes, you'll certainly still be able to argue it.
Have a think about going down what was 276 ADE, very significant obstacles to integration, which is now PL something 5.1. Yeah. But the test is still the same, but that might be a route in to get it considered, and hopefully your private life will be engaged in any event, definitely. So yeah.
Great. Okay, the next question I think could be for either of you. It's a rather long and slightly complicated, so I'll read it slowly. You may want to read it as well. So client A has a certificate of application dated 18th of June 2021. Refusal of EUSS dated 4th of September 2021. A was absent since 2016 for an important reason, as trying to keep a failing marriage in the interests of children attending school in France. This was never documented PR under the regulations. An administrative review was submitted 1st of October 2021. There's no decision yet. A is self-employed and has continued to work on Zoom with UK clients. Whilst AR pending, can A return to the UK on the strength of COA and continue to work pending the final outcome of EUSS? What provision in EUSS can they rely on?
Wow, this is probably a bit too case specific for an event like this. This is one of those ones where you say contact one of us afterwards.
I would say so.
Again,
I mean, we don't even know on what basis the application has been made, actually.
But it sounds like, again, there would be difficulties in returning to the UK on the strength of a COA, definitely. So I think there have been difficulties, but this is not the sort of, I think that it's too case specific to answer on an event like this, especially given it's so technical in terms of the EUSS, which we all know, including Court of Appeal judges, makes their head hurt very much. Yeah.
Okay, great. Right, let's look at this next live question, I think to either of you. A wife of an EEA national with pre-settled status who married after Brexit but has a child in the UK. Can she apply for pre-settled status?
Well, she's married after Brexit, then unfortunately Batul and Chalik will apply. But she may well be able to apply under Appendix FM. And it may well be that dependent on the child status, the child may be British. It may well be that there's an application to be made on the basis of the child. Adam?
No, when my gut reaction was that because of the post-Brexit marriage, that was the problem in terms of going down the EUSS route, and it may be that he has to go down an Appendix FM Article 8 route on the back of the child, certainly.
Okay. We're getting close to the end here, but I think we probably have time for one more. This is to Adam. In deprivation of citizenship cases, how is the best way to argue Article 8?
Just given this is probably our last question, practitioners will be aware of the last couple of years, the number of deprivation cases has gone through the roof. At the same time, following the judgment of the Supreme Court in the Shamina Begum litigation, deprivation cases have got much harder because they've, even though that was conducive to the public good deprivation, they've applied the same approach in fraud deprivations, and most of the ones we deal with are in that category, and they're applying a rationality review. Human rights stands apart from that, and the tribunal can still consider human rights for themselves, but it's considering Article 8 in the context of deprivation, not in the context of removal, of which there'll be a separate consideration. So I think you've got to focus very much on the consequences of deprivation. Now, often there's perhaps a limbo period. There are also the Laci case, LACI, about a huge Home Office delay. That can be relevant, and one of those cases where you may have an argument in terms of Article 8 in deprivation, but deprivation cases have got much more difficult. But that, as practitioners, don't be afraid of them, because there are, if you're looking for a source of work, there are definitely a huge amount of deprivation, largely in terms of perhaps those who claim to be Kosovan nationals, and it turns out they were Albanian all along. And we know that's a big focus of the Home Office at the moment. So do be prepared. Look at the summary from the upper tribunal in the Ciceri or Circe case. I never know how to pronounce it, but that case summarizes the current approach. I don't know. I know we're close to the end, Priya, if you had any thoughts on deprivation.
No, Adam, I think that you've set out the position well there.
Brilliant. Well, this brings us to the end, just a couple of minutes to go. So it's all we have time for today, but thank you so much for attending. Law 2022 Online, Immigration Law Shape the Debate, sponsored by us, Trinity College London. Want to thank our expert speakers, Adam Pipe and Priya Solanki. Don't forget to join the solicitors group LAW2022 Online community on LinkedIn to continue the debate after this live session and also to be included in exclusive offers for the next time. As I mentioned at the beginning, a recording of today's session will be sent out by email within 48 hours. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. A feedback form for the event is found in the related links section of the online course, and after submitting this, you will receive your CPD certificate via email. Please also don't forget to visit the online exhibition at thesolicitorsgroup.co.uk. By visiting the exhibition, you can access a free 1-hour CPD webinar from our webinar learning catalog, and you can also visit our exhibitor profile for more information about us, Trinity College London. Thank you again for joining us, and have a great day, everyone.
Thanks, everyone.
Bye-bye.
Thank you.